And Your Honor, if this case were to proceed to trial, the state would expect to show that on October 26, 2025, officers responded to Aaron Road Southwest in South Fulton, which is in Fulton County, Georgia. And they responded to a complaint made by Ms. Gaddy. Ms. Gaddy was visibly upset and advised that she had been involved in a physical altercation with her husband, Mr. Gaddy. She stated that they had been together for approximately 18 years, and she advised earlier in the evening they hosted a small couples gathering at the residence. After the guests left, an argument related to their current process of separation occurred, and Ms. Gaddy stated that while she was in the bathroom, Mr. Gaddy entered, confronted her, and during that argument placed both hands around her neck, choking her and pushing her against the mirror. She stated that Mr. Gaddy yelled at her while choking her that you have me effed up if you think I'm going to let someone else have you. Ms. Gaddy stated that she was unable to breathe and believed that she was about to lose consciousness. Ms. Gaddy stated she need Mr. Gaddy in the growing area to get free and ran downstairs to her adult son for help. She reported that while fleeing, she told her son to get him. And as Mr. Gaddy began gathering his belongings to leave, he removed a mounted television from the wall and exited the home. And as he was outside, he struck her vehicle with a hammer, shattering multiple windows. And that concludes the state's portion, Your Honor.
Okay. So I understand sometimes after you interact with the alleged victim in the case, you would elect to downgrade the offense that alleges the physical violence and the nature of that. The hammer to the car is the seriousness of the offense is driven more by whatever it costs to fix. And in the indictment, it says 7 windows and more than $500. Has Ms. Gaddy said it wasn't 7 windows or it wasn't $500? Or I'm just curious why you're downgrading that one. Not challenging it, but that's one where it was or it wasn't.
Ms. Gaddy has never provided us with documentation of that.
Okay.
At the indictment stage, typically there's a verbal conversation and then there needs to be subsequent documentation to prove it.
Got it.
Based on her current state of not wanting to really move forward, Ms. Gaddy does not plan to provide me with such documentation.
Was there a body cam showing lots of broken windows on the Acadia?
There is visible physical damage to the vehicle. The state's issue would be proving the cost of that damage.
Got it. It's at minimum trespass. It's
Correct.
bashed up. But the value of that, you'd need cooperation from Ms. Gaddy.
Correct.
Okay. Got it. All right. Criminal history.
It's like 2019 as it's all, I mean, it's simple self-conviction. I've seen it though.
Okay. Now you are on probation right now, Mr. Gaddy, for what?
Altercation I had with my son.
With your son?
Yes.
Okay. Is this the same son who was home when this happened?
Yes, sir.
Okay. And is he an adult?
Yes, sir.
How old is he?
21.
Okay. All right. Did you share with me what the conditions were of probation?
Yes, Judge, I'll go back to them.
I know it's 24 months.
No violent contact, complete family violence intervention program, complete 60 hours of community service, and seek and maintain gainful employment.
Okay. So they can continue to interact. It just needs to not be tumultuous.
Yes, Judge, and I did speak with Ms. Gaddy about that because I actually mentioned to her that since they were dealing with an adult child, that typically I would just do no contact, but she said that she thinks that would make the separation process much harder.
Okay.
So she would prefer no violent.
Got it. Okay. All right, Ms. Wood.
Thank you, Judge. It's my understanding that Mr. Gaddy has paid for the repair to the vehicle. So I wanted to share that with the court. As you heard, he's 44. He's a high school graduate. He has 3 children that he shares with her. He is eager to put this behind him so that they can hopefully move forward in a safe, productive, co-parenting way. And I believe that is all I have for the court. We just ask that you accept the state's recommendation.
All right. Mr. Gaddy, 3 kids. I've heard about the son, who you said is 21. I think you said
Yes.
21. How old are the others?
15 and want to be 9 Saturday.
Happy birthday. And the 15 and 9-year-old.
It's 2 15s, I'm sorry. They're twins.
Oh, so there are 4. I guess the 21-year-old you don't think of as a kid so much because he's on his own.
Yes.
So a total of 4,
Yes,
2 15-year-olds and a 9-year-old.
yes, sir.
Got it. So the 3, I'll call them kids, the 3 kids, do they stay primarily with you or Ms. Gaddy or?
At the moment, they're with their mom, but once I get my residence, my kids are coming with me. We talked about it in separation and everything, so the kids will
Okay.
come.
And they'll visit you or they'll stay with you full time?
Yes, sir.
Okay. Do you have a written arrangement with Ms. Gaddy about that?
That's something that we have to
Work through.
Yes.
Okay. All right. And tell me what kind of work you do.
I work for Home Depot Pro Warehouse in East Point. I'm a yard switcher in a GWA.
A what?
Yard switcher.
Yard switcher, meaning you move trucks around?
Yes, I'm.
Got it. You drive that funny looking little thing that just sort of pops them around in the yard. Got it. Okay. And that's a full time?
Yes, sir.
All right. Do you have any questions about anything we've covered?
No, sir.
Judge, sorry, I forgot to add, in case you want to structure the sentence differently, he did serve 56 days for this case.
Oh, okay. Thank you. I forgot to check that. So the Aaron Road address, which is listed in here, is where this situation happened.
Yes,
Are you
sir.
still living at home?
No, sir.
Okay, but you are looking to secure a permanent residence and then the kids can be with you.
Yes, sir.
Right now, it's a temporary situation?
Yes, sir. Because I just got a promotion at my job, so I'm able to. My finances are able to where I can get my own place now, to where I can house my kids with me.
Okay, well, congratulations on that.
Thank you, sir.
All right. Well, if you don't have any questions, Mr. Gaddy, you've answered mine. I appreciate that. I find there's a factual basis for this plea. You and Ms. Gaddy are going to continue to go through a difficult situation as you disentangle after many, many years of being together. And you're going to need to make sure that the very natural emotions that flow from that you channel in a different way. You may feel very justified in being upset or hurt or whatnot, but you need to take it out on a punching bag or by running or pulling 2 trucks at once instead of 1, whatever it is that gets that out of your system. Obviously, what happened on the 26th, and I know there are 2 sides to it. I'm not saying it was just you jumping her, but we don't need to go there. Whatever happened, both of you would need to figure out a way to de-escalate that. But the focus is on you. You're the one who got arrested and the one with these charges. I am going to sentence you on count 1. Well, first, I find that, as I said, there's a factual basis for this. And 2, that your plea is knowing, meaning you've understood what we talked about. And 2, it's voluntary. No one is forcing you to enter this plea. Do you agree with that?
Yes, sir.
Okay. Ms. Wood, do you authorize someone at my office to sign the indictment on your behalf as well as your client's behalf?
Yes, Judge.
Ms. Willingham, can we get someone to sign for you?
Yes, Judge.
All right, we'll do that. Mr. Gaddy, count 1, which is being reduced to family violence battery, and know this, that's your first and only misdemeanor family violence battery. If you are accused of and prosecuted for another putting your hands on someone who would constitute a family member, and that could be someone in the future who's not part of your family yet, and certainly it would be all your kids, that's a felony. So you're kind of using up your misdemeanors here. But it's a misdemeanor. And for that one, I'm sentencing you to 12 months to serve 2 months, but you'll get credit for the 2 months you already served with the balance on probation. Count 2 is 12 months probated consecutive. So instead of 24 months probation, it's 22 months probation. Special condition number one, the most important one, no violent contact with April Gaddy. Number two, you need to complete family violence intervention program. That's a series of classes, and you will need to enroll in the FVIP program within the first 2 months of your probation. Not finish it, but you got to get it started. So you'll provide proof of enrollment to your probation officer by the end of August, basically, 2 months from now.
Okay.
And then number three, you need to complete 60 hours of community service, and you need to do that within the first 6 months of your probation. That way, the tail end of your probation is just you living your own life, and you don't have these direct obligations, FVIP or community service, to probation. And they may decide you took care of the substantive stuff, things are good with Ms. Gaddy, maybe they'll end it a little early, but that's based on how well you're doing with them. Ms. Wood, anything else on behalf of Mr. Gaddy?
No, Your Honor, thank you.
Ms. Willingham, on behalf of the state?
Nothing, Your Honor.
Okay. Did you fill out the magic form, or you will fill it out with your client?
Yes, I'll
Okay.
get it back.
Please don't leave Mr. Gaddy until you and Ms. Wood fill out that form that will get to misdemeanor probation all your contact information. They'll contact you. So if you get a strange phone call, if you want to let it go to voicemail, that's fine, but make sure you call them back. If they let me know, we've called him, we've emailed him, and you're not getting back, then I'll say, take out a warrant. I don't know what else to do. So definitely be responsive to